Somewhere between courtroom dramas, Reddit threads, and that one uncle who knows a guy, we've picked up a lot of legal nonsense. From shouting, "I know my rights," like it's a spell, to believing that asking, "Are you a cop?" forces the truth. Our understanding of the law is often just TV reruns and vibes. So today, we're cracking open the top 50 legal myths people still cling to like they're written in the Constitution, in crayon. 1. The idea that an undercover cop has to tell you they are a cop if you ask is maybe the most pervasive legal myth of all time. It's also completely laughably false. Think about it for a second. The entire concept of undercover work would collapse. It would turn every sting operation into a polite game of guess who, except everyone loses and someone ends up in handcuffs. The legal concept people are fumbling for here is entrapment, which isn't asking someone if they're a cop. It's coercing someone to commit a crime they weren't already predisposed to commit. If you're looking to buy illegal goods and ask your dealer, "Are you a cop?" they are legally allowed to lie right to your face. 2. You can, in fact, yell fire in a crowded theater. This myth comes from a 1919 Supreme Court opinion that was overturned decades ago. The original phrase, falsely shouting fire in a theater and causing a panic, was used as an example of speech not protected by the First Amendment. The key word there is falsely. If there is an actual fire, please, for the love of all that is holy, yell fire. The modern legal standard is that you can't use speech to incite imminent lawless action. So yell fire if there's a fire. Just don't yell aliens unless you're ready to test the Stampede protocol. 3. You do not have a constitutional right to one phone call after being arrested. This is a pure Hollywood invention, designed to create a dramatic moment where the hero has to choose between calling his lawyer or his loved one. The reality is far less cinematic. You have the right to an attorney, and to facilitate that, states have laws allowing you access to a phone. The number of calls you get and who you can call varies by jurisdiction. In real life, there's no dramatic dilemma, just a bored cop handing you a phone and hoping you don't call your ex. 4. If the police arrest you but forget to read you your Miranda rights, you don't automatically go free. This isn't a get-out-of-jail-free card. The Miranda warning is only required before a custodial interrogation. If they don't read you your rights, it just means that any confession or incriminating statements you make during that interrogation can't be used as evidence against you. The arrest itself is still perfectly valid, and any other evidence they have, physical, witness testimony, you name it, is still fair game. The case can, and often does, proceed without your confession. Congrats! You gave them everything, without even getting a lawyer cameo. 5. It's not strictly illegal to destroy money. Everyone seems to think that tearing a dollar bill in half will get you a visit from the Secret Service. The actual law states that it's illegal to mutilate, cut, or deface currency with intent to render such bill unfit to be reissued. The key phrase is intent. The law is meant to stop counterfeiters or people trying to pass off damaged bills as more valuable ones. If you tear up a 20 in a fit of rage or for an art project, the Treasury Department isn't going to scramble a black helicopter. Unless you're folding 20s into throwing stars and launching them at a bank, no one cares. 6. You can't just get a quickie annulment because you had a drunken Vegas wedding. An annulment isn't an easy divorce. It's a legal declaration that your marriage was never valid in the first place. The grounds for it are incredibly specific and serious, like bigamy, incest, or fraud, where one person was tricked into marriage. Regretting your Elvis-officiated nuptials after the tequila wears off isn't one of them. What you're looking for in that situation is a good old-fashioned, and often much more complicated, divorce. Turns out, what happens in Vegas usually needs a lawyer in Reno. 7. Prenuptial agreements are not just for the mega-rich. The media portrays prenups as a tool for billionaires to protect their empires from gold diggers. In reality, they are practical financial planning documents for regular people. A prenup can protect you from your partner's massive student loan debt, outline how a shared business will be handled, or clarify ownership of property you brought into the marriage. It's less about distrust and more about having an honest, if slightly awkward, financial conversation before you tie the knot. Think of it less like betrayal, more like installing airbags before driving off the relationship cliff. 8. You can't sue anyone for anything in America. While our legal system is certainly active, the idea that you can successfully sue for any perceived slight is a myth, largely fueled by media reports on outlier cases. To bring a lawsuit, you need to have standing, which means you must have suffered a concrete and direct injury. You can't sue your neighbor because their bad taste in garden gnomes causes you emotional distress. A judge would throw that out as a frivolous lawsuit before you could even say objection. Courtrooms aren't Yelp. You don't get to leave a 1-star review because your neighbor painted his shed mauve. 9. Crossing a state line doesn't magically make a crime more illegal. TV shows love the trope where a local sheriff chases a bad guy to the state line and has to stop, saying, "He's crossed state lines. It's a federal matter now." While crossing state lines can trigger federal jurisdiction for certain crimes like kidnapping or car theft, it doesn't add a new layer of criminality. It just changes which agency investigates and prosecutes, the FBI instead of the local police. You're not in more trouble, you've just upgraded from local jail to a federal folder with your name spelled correctly. 10. Making a citizen's arrest is an incredibly bad idea. The image of a heroic bystander tackling a purse snatcher and yelling, "I'm making a citizen's arrest," is a fantasy. While the concept exists in some states, it's a legal minefield. The rules are complex and vary wildly. Generally, you have to have witnessed a felony being committed. If you get it wrong and mistake a misdemeanor for a felony, or misunderstand the situation entirely, you are the one who can be arrested and sued for assault, battery, and false imprisonment. So unless your dream is to get sued in 2 directions at once, just call 911. It's safer for everyone. 11. Entrapment is not a cop simply offering you the chance to commit a crime. This isn't a video game where you get a pop-up that asks, "Would you like to break the law? Yes, no." Entrapment requires law enforcement to induce or persuade a person to commit a crime that they were not otherwise predisposed to commit. If a cop asks, "Want to buy some illegal fireworks?" and you immediately say, "Yes, how much?" that's on you. Entrapment is a high bar involving persistent coercive tactics. It's not a magic word you can invoke just because you got caught. 12. Diplomatic immunity is not a golden ticket to cause chaos like a villain in a Lethal Weapon movie. The myth is that diplomats can commit any crime without consequence. The reality is much more bureaucratic. While they are immune from prosecution in their host country, their home country can, and often does, waive that immunity for serious crimes. And for lesser offenses, the consequence isn't jail. It's being declared persona non grata and getting kicked out of the country. It's less like a license to kill and more like a fast pass to being grounded on a global scale. 13. If you find buried treasure in your backyard, it's not automatically yours. The finders keepers rule died in the sandbox. In reality, the law is a complex mess of lost, mislaid, and abandoned property rules. If the original owner can be identified, they almost always have a claim. And if it's considered an antiquity or treasure trove, like ancient coins, the government will likely step in and claim it. So that dream of finding pirate gold usually ends with you finding a lawyer, an angry neighbor, and the IRS, all wanting a piece of your discovery. 14. You absolutely can be convicted on circumstantial evidence alone. In fact, most convictions are. Courtroom dramas have broken our brains, making us think a case is weak without a smoking gun or a tearful confession on the stand. But direct evidence is incredibly rare. Circumstantial evidence is the collection of facts that, when put together, paint a picture of guilt, motive, opportunity, fingerprints on the scene, a suspicious alibi. It's not one thing, it's everything. Most criminal cases are less like a photograph and more like a detailed mosaic, built piece by incriminating piece. 15. Yelling, "I know my rights." Add a police officer is not a legal force field. While you should absolutely know your rights, declaring it loudly during a tense situation often does the opposite of what you think. It doesn't stop a lawful arrest. If an officer has probable cause, they can arrest you. Arguing and resisting can simply add more charges, like obstruction or resisting arrest. The fantasy is a powerful citizen standing up to the man. The reality is often that citizen accidentally giving the man more paperwork to file against them. 16. Accidentally opening someone else's mail won't get you sent to federal prison. Yes, tampering with mail is a serious federal offense, but the law is all about intent. It was written to stop people from stealing mail or intentionally obstructing its delivery for nefarious purposes. If you accidentally open your roommate's credit card bill because you were on autopilot, you haven't committed a crime. The FBI isn't going to rappel through your window because you mistakenly opened your neighbor's Crate and Barrel catalog. They're looking for thieves, not the absent-minded. 17. Confessing to a crime does not automatically get you a lighter sentence. The movie trope of a heartfelt confession leading to a judge's tearful mercy is pure fiction. In the cold, hard world of the justice system, a confession is simply the most powerful piece of evidence the prosecution can have against you. It's a gift-wrapped conviction. While it can be a bargaining chip in a plea deal, it's not a coupon for leniency. You haven't unlocked a secret mercy level. You've just handed the other team the game-winning touchdown. 18. You can't go to jail for most debts, but people hear debt and think it's a universal rule. It's not. You won't be imprisoned for failing to pay your Visa bill or a medical invoice. However, you can absolutely be jailed for willfully refusing to pay certain court-ordered debts. This includes things like child support, alimony, and certain taxes or court-imposed fines. The myth is that debt is a civil matter. The reality is that when a judge tells you to pay, it stops being a suggestion and becomes an order you ignore at your own peril. 19. The insanity defense is one of the most abused tropes in fiction and one of the rarest strategies in real life. It's used in less than 1% of all felony cases in the United States, and it's successful in only a fraction of those. And winning isn't a get-out-of-jail-free card. It means being committed to a secure psychiatric hospital, often for a period far longer than the prison sentence would have been. The myth is a clever criminal duping the system. The reality is a grim, often indefinite, confinement inside a different kind of institution. 20. The saying, "Possession is 9/10 of the law," is 99.9% false. This folksy proverb has absolutely no real legal standing. Ownership is determined by legal documents like titles, deeds, and bills of sale, not by who is physically holding an item. If you steal your neighbor's lawnmower, the fact that it's in your garage doesn't make it 90% yours. It just makes you a thief who's really bad at hiding evidence. This logic doesn't work for your roommate's PlayStation, and it definitely won't work for your neighbor's Ford F-150. 21. An oral agreement is not a legally binding contract. This is a myth beloved by people trying to weasel out of a deal. While written contracts are always better, a verbal agreement can be just as enforceable in court. The movie fantasy is a dramatic courtroom reveal of a signed document. The reality is a messy, he said, she said argument. The problem isn't that a verbal deal isn't a contract, it's that your star witness is your own fuzzy memory, and that's not something you can submit as Exhibit A. 22. If a store has an item priced incorrectly, they have to sell it to you for that price. This is the official myth of every person who has ever demanded to speak to the manager. The truth is, a price tag isn't a binding contract. It's legally considered an invitation to treat. It invites you to make an offer to buy the item at that price. The store is then free to either accept or reject your offer. Legally, that mislabeled $10 big screen TV is just an invitation to make an offer the store is perfectly free to laugh at. 23. Silence equals consent. This one isn't just dumb, it's dangerous. In both social and legal contexts, particularly concerning assault, this is absolutely false. Consent must be affirmative, enthusiastic, and clearly communicated. It's an active yes, not the passive absence of a no. In the eyes of the law, thinking that someone's silence grants you permission is like thinking a closed bank is giving away free money. Your silence doesn't grant permission. It just means you haven't said anything yet. 24. Contrary to popular belief, simply living together for a long time does not automatically make you common law married. You don't unlock marriage like a hidden level in a dating app. Only a few states even recognize common law marriage, and even there, you usually need to present yourselves publicly as a married couple. Joint bank accounts, shared last names, or telling people you're spouses. If your relationship looks more like roommates who split Wi-Fi than a married couple, the law agrees. 25. If someone gets hurt on your property, you're automatically liable. This myth fuels the nightmares of every homeowner. The law isn't a simple, your property, your problem equation. To be held liable, you generally have to have been negligent. This means you knew about a dangerous condition, like a rickety staircase, and did nothing to fix it or warn people. Just because your clumsy friend trips over his own feet on your perfectly safe driveway doesn't mean you owe him a new car. You have to be negligent, not just unlucky enough to have friends with bad coordination. 26. It's illegal to read someone else's diary. While it's a Class A felony in the court of sibling rivalry and a one-way ticket to being socially exiled from family dinners, it's generally not a crime. The law protects against things like burglary, breaking in to get the diary, or defamation, publishing its contents to harm someone. But the simple act of reading it, while a massive betrayal of trust, isn't something the police are going to get involved in. The law protects you from trespassers, not nosy relatives. 27. You can't be convicted of murder without a body. This is a favorite trope of crime novelists and would-be criminal masterminds. While it makes the prosecution's job much harder, people are convicted of murder without a body all the time, based on overwhelming circumstantial evidence. Telling a jury, but you don't have the body, when they have your DNA, the victim's blood in your car, and a YouTube search history for how to dissolve a body is a losing argument. It's not no body, no crime. It's no body, no parole. 28. Anything you say off the record to a journalist is legally protected. Saying off the record to a reporter isn't casting a legal spell that gags them. It's a professional, ethical agreement, not a legally binding one. If a journalist publishes something you said off the record, they can't be sued for it, but they will instantly destroy their career and reputation among their sources. The only thing stopping them from publishing is their professional ethics, not a federal judge. It's a pinky swear with potentially huge consequences. 29. It is illegal for police to lie during an interrogation. This might be the most dangerous myth to believe if you ever find yourself in a little room with a two-way mirror. The Supreme Court has repeatedly affirmed that police can, and do, use deception as a tactic to get a confession. They can lie and say they have evidence they don't, or that your accomplice has already confessed and pinned it all on you. Their job is to close the case, not to play by the rules of polite conversation. 30. You can sue a fast food company for making you obese. The infamous McDonald's lawsuit that lodged this idea in our heads was not a simple case of "your food made me fat." It was ultimately dismissed. The courts have consistently sided with the idea of personal responsibility. You can't sue a company for a risk you willingly and knowingly took. No judge in the land will award you damages because you were somehow surprised to learn that eating a triple cheeseburger and a large fries every single day isn't part of a balanced diet. 31. The myth that you can declare yourself a sovereign citizen and become immune to the law is perhaps the most bizarre on this list. Adherents to this fantasy believe that by using magic words like "I am a freeman" on the land and putting a gold fringe on a flag, they can simply opt out of things like taxes, traffic laws, and basic civic duties. The reality is that this has never, not once, worked in a court of law. All it does is turn a routine traffic stop into a felony arrest. You can't declare your basement an independent nation to avoid property taxes, and you can't claim to be a traveler instead of a driver to get out of a speeding ticket. 32. Stand your ground. Laws are not a license to engage in a Wild West shootout. The myth suggests you can use deadly force anytime you feel vaguely threatened. The reality is that these laws simply remove the duty to retreat before using force in self-defense, but the force must still be proportional to a credible, imminent threat of great bodily harm or death. You can't shoot someone for ringing your doorbell too aggressively or for looking at you funny in a parking lot. It's a legal defense to be argued in court later, not an invitation to be the judge, jury, and executioner on your front porch. 33. Police do not always need a warrant to search you or your property. We've all seen the movie scene where a character smugly says, "You can't come in without a warrant." In reality, the list of exceptions to the warrant requirement is long and well established. This includes the plain view doctrine, if they can see illegal items from a lawful vantage point, consent, if you let them in, and exigent circumstances, like if they hear cries for help or believe evidence is being destroyed. Yelling for a warrant while standing next to a mountain of cocaine is not the legal checkmate you think it is. 34. Signing a contract doesn't mean you're bound by it, no matter how ridiculous or illegal the terms are. A signature is powerful, but it's not magic. A contract can be deemed unenforceable if its terms are illegal. For example, a contract to commit a crime. It can also be voided if it was signed under duress, or if it's unconscionable, meaning it's so outrageously one-sided that it shocks the conscience of the court. Signing a gym membership that says, "You owe them your soul and your firstborn child" won't hold up. The judge has seen it all, but they draw the line at deals that belong in a medieval fable. 35. The castle doctrine does not allow you to set booby traps for intruders. Your home is your castle, but you can't turn it into the set of Home Alone. The law protects your right to defend yourself against an active threat inside your home, but it does not give you the right to use indiscriminate, deadly force. A spring gun or a pit of spikes can't tell the difference between a dangerous burglar, a paramedic trying to save you, or a neighborhood kid looking for their lost dog. If your trap harms someone, you are the one who's going to be facing a judge. 36. Getting divorced does not mean you automatically split everything 50-50. The myth of a simple 50-50 split comes from community property states, but most states follow equitable distribution. And equitable does not mean equal, it means fair. A judge will look at the length of the marriage, each person's earning potential, who has custody of the children, and what assets were brought into the marriage. The court isn't a deli slicer dividing a sandwich in half. It's more like a tired referee trying to fairly divide the assets of a team that no longer wants to play together. 37. It's not automatically theft the second you walk out of a store with an unpaid item. Before you test this, know that the key legal ingredient for theft is intent. A prosecutor has to prove that you intended to permanently deprive the owner of their property. If you genuinely forgot a pack of gum was on the bottom of your shopping cart and walk out, you haven't committed theft. You've just had an embarrassing moment. The legal line between a criminal and a forgetful shopper is proving you meant to steal the item, not that you were just distracted by a screaming toddler. 38. It is absolutely not illegal for you to discuss your salary with your coworkers. In fact, it's the opposite. For most private sector employees, company policies that forbid discussing wages are themselves illegal. The National Labor Relations Act of 1935 gives you the right to engage in concerted activities for mutual aid or protection, and that includes talking about pay. This myth only benefits employers. That hush-hush company culture around salaries isn't just a tactic to keep wages down. It's often a direct violation of federal law. 39. Receiving a gift does not make it immune from taxes. This isn't a magic loophole to avoid the IRS. While the recipient of a gift usually doesn't have to pay taxes on it, the giver might. The IRS has an annual gift tax exclusion, and if you give someone a gift valued above that amount, say a car or a down payment on a house, you may have to file a gift tax return. Trying to explain to the IRS that your new six-figure salary is actually just a weekly gift from your employer isn't a clever workaround. It's an invitation for a very thorough audit. 40. You can, in fact, record a conversation without the other person's consent. But be very careful. This myth exists because the law is a chaotic patchwork that varies from state to state. In one-party consent states, you can legally record any conversation you are a part of. But in two-party or all-party consent states, you need everyone's permission. Before you hit record to catch your roommate admitting they're the one who keeps stealing your oat milk, you'd better Google your state's laws. You could go from being a dairy detective to an accidental felon. 41. You can't sue someone for emotional distress just because your feelings were hurt. This isn't a legal version of retail therapy. To win such a case, you need to prove the other person's behavior was truly outrageous. Think stalking, threats, or something that would make a jury collectively wince, and that it caused severe psychological harm, often confirmed by medical professionals. Being mildly offended, ghosted, or subtweeted doesn't qualify. Court isn't your group chat, and the judge doesn't care about your screenshots. 42. Pleading the fifth does not mean you're guilty. In the court of public opinion, invoking your right against self-incrimination is often seen as a confession, but in a court of law, it's a fundamental constitutional right, and the jury is explicitly forbidden from drawing any negative inference from it. It's a strategic legal move. You might plead the fifth because you're guilty, or because you're innocent, and your lawyer knows the prosecutor is trying to twist your words into a pretzel. It's not an admission, it's a refusal to play a game you're likely to lose. 43. You cannot copyright an idea. This is the great myth of every aspiring creator. You might have the greatest idea for a movie about a time-traveling hamster, but you can't legally protect the concept itself. Copyright protects the specific expression of an idea. The written script, the finished film, the detailed drawing of the hamster in his tiny DeLorean. The idea itself is free for anyone to use. That's why there can be a dozen different movies about an asteroid hitting Earth, and no one is suing anyone. 44. It is not illegal to drive with the interior dome light on in your car. This is the king of all dad myths, passed down from generation to generation as gospel. While it's certainly a bad idea because it can reflect on the windshield and reduce your night vision, there is no state law in the US that specifically makes it illegal. An officer could potentially pull you over for distracted or obstructed driving if it's genuinely causing a hazard, but the act itself isn't a crime. You can finally tell your dad he was wrong. 45. Self-defense does not cover protecting your property. The idea that you can use force, especially deadly force, to stop someone from stealing your stuff is a dangerous fantasy. The law overwhelmingly values human life over property. You can use reasonable, non-deadly force to prevent a theft in progress, but the second the thief is running away with your television, your right to use force generally ends. Using deadly force is typically only justified to prevent an imminent threat of death or serious bodily harm to a person, not to your new flat screen. 46. Squatters' rights are not an easy way to steal a house. The legal term is adverse possession, and the myth is that if you live in an abandoned house for a while, it's yours. The reality is a legal marathon designed to be almost impossible to win. You typically have to possess the property openly, exclusively, continuously, and without the owner's permission for a very long statutory period, often 10 to 20 years. And in many places, you also have to pay property taxes on it the entire time. It's not a sneaky loophole, it's a legal doctrine so difficult it rarely ever works. 47. You can sue the government. The myth is that the government has sovereign immunity and is untouchable. While sovereign immunity is a real concept, governments at all levels have passed laws, like the Federal Tort Claims Act, that waive this immunity for many types of lawsuits. It's a complicated, bureaucratic process with lots of special rules and shorter deadlines, but it's not impossible. The government can't just be negligent, cause harm, and then hide behind a legal shield from the 14th century. It's just much, much harder to win. 48. Anything you say to your lawyer is not automatically confidential. The attorney-client privilege is one of the strongest protections in the legal system, but it's not absolute. The key exception is the crime-fraud exception. If you're seeking legal advice to help you commit a future crime or fraud, that conversation is not privileged. Your lawyer is an advocate, not your co-conspirator. They are ethically bound to keep your past secrets, but they are not legally obligated to help you plan your next bad idea. 49. Double jeopardy does not mean you can't be tried for the same crime twice, period. The Fifth Amendment protects you from being prosecuted again for the same crime after a final judgment has been reached, an acquittal or a conviction. But it doesn't apply if the trial ends in a mistrial or a hung jury. Furthermore, it doesn't prevent you from being tried for the same act in both state and federal court, under what's called the dual sovereignty doctrine. It's a shield against endless government harassment, not a one-and-done free pass. All right, we've dissected 49 myths, and there's just one final entry to go. But before we get to number 50, it's time for the final verdict. In our opinion, the award for the most incredible myth on today's list goes to the sovereign citizen. Simply because it's the only legal theory that requires you to believe you're the main character of the universe, and that the universe is legally obligated to agree with you. Do you agree with our verdict? Or did another myth deserve this dubious honor? Let us know in the comments what you think. And now, our final number. 50. The belief that you are innocent until proven guilty. This is perhaps the most misunderstood principle of all. It is not a social guarantee, it's a procedural rule for the courtroom. It means the burden of proof is on the prosecution, and the jury must presume you are not guilty when they begin deliberations. It does not stop you from being arrested, held in jail pending trial, fired from your job, or being eviscerated in the court of public opinion. It's a critical safeguard inside the courtroom, but it offers zero protection from the consequences outside of it. If you've made it this far without yelling "objection" at the screen, congrats! You're already smarter than most courtroom characters on TV. But let's settle one more case. Which myth was the absolute dumbest? Was it the sovereign citizen fantasy, the bodiless murder defense, or the belief that your dome light makes you a fugitive? Hit the comments with your pick, but prepare to defend your verdict. And hey, if you enjoy watching myths get obliterated with facts and sarcasm, slam that like button, subscribe for more, and remember, ignorance of the law might not be a crime, but it sure is entertaining.